Okay, gentlemen, you can begin.
It is 32.5. Plus 1 is 33.5. And then, because of the 0.5, that must go into the next whole number, and it brings it to 34. There are many cases that we have now found that calculate it that way in a number of jurisdictions where prominent judges of the Court of Appeal have done that kind of computation.
This, we are part of a nationwide stand-up against this illegal, unconstitutional and unlawful Granger-led administration. Yesterday concluded the 90-day period by which an election should have been called since the passage of the no-confidence motion on December 24th. We in Region 10, we are standing up here at the entry and exit of all who come through Region 10 to let them know that this government is illegal and we are demanding elections now. So we are just a part of what is happening across the entire nation. Region 10, the residents of Region 10, we are standing up here today for our constitutional right. A president must not take away our right to vote. We should have had elections, and we want those elections now. Granger and his band must not illegally hold on to power and stay in office. Obey the Constitution.
Okay, gentlemen, you can begin.
Good afternoon again from Georgetown, Guyana, and with me in the capital of Guyana, our opposition parliamentarian for the People's Progressive Party, Juan Edghill, and Minister of Public Security, Khemraj Ramjattan, who is also chairman of the Alliance for Change, the party that is partnership with the APNU in a governing coalition. On this week's program that is being promoted by Globespan 24/7, we are focusing on the topic clarity of the Court of Appeal's decision and moving forward. I'm your host, Dennis Chabrol, And of course, we'll be looking forward to our listeners joining us from across the globe and also from our live audience in New York, who will be joining us as part of an in-studio participatory panel. They'll be asked to provide their questions in a very brief manner so that we do not have any speeches focusing directly only on the question. And also, we'll be taking questions via the phone. You're free to call in and give your questions, and our panelists will, of course, be focusing on the topic at hand, that is clarity of the Court of Appeals decision and moving forward. As I said earlier, yesterday, Guyana's Court of Appeal, in essence, invalidated the December 21, 2018 no confidence motion, saying that, indeed, that motion was not properly passed by an absolute majority of 34. In fact, the vote was passed back then, at least so it was believed, but by a majority of 33 of all of the elected members of the National Assembly. First, Mr. Ramjattan, welcoming both of you, Mr. Edghill and Mr. Ramjattan. Welcome to the program.
Thank you very much, Dennis, and welcome, Bishop.
First of all, my question is, from a legal perspective, Mr. Ramjattan, you're a well-known lawyer, apart from a politician in Guyana. How does one define what is an absolute majority as opposed to a simple majority for our listeners looking at the context of what transpired yesterday in Guyana's Court of Appeal?
Well, I think it is exactly what the majority judges of the Court of Appeal did. The majority, absolute majority it is, although the word absolute is not used there, the formulation as distinct from the other sections, articles of the Constitution, revealed a very distinct and different meaning, obviously. And that was what we were arguing. And so it was not an argument that was felt attracted to by the Chief Justice, nor Mr. Rishi Prasad, Justice of Appeal, but it found attraction with Yonat Cummings, Chancellor Acting, and of course the other Court of Appeal judge. It has to do with the two principles. Whenever you have a situation like an odd number, whereby you divide by half, you plus one, and if there's a fraction, it goes up to be rounded up, upwards. There are case law in that, and I think it was all explained, and the expositions were given to by these three judges there yesterday. And one distinctly argued the case that it should not be that manner, and so on. The other two held it, upheld it. Of course, we now understand that it will go up for an appeal to the Caribbean Court of Justice, and that is all the time what the government was saying. We would like this to be brought to certainty, to clarity, to finality. And I think, yes, now that in a sense we have won on a 2-1 majority as to what the threshold is, it is the best thing to go to the Caribbean Court of Justice to find out if indeed that is so. And if I feel confident it will be so, but of course you can never say. But at least whatever they ruled and pronounced on, that will be final.
Mr. Edghill, do you believe that after all of the hype, that your party, that's the People's Progressive Party, with which you're associated, if not a member, is really disappointed? And where does it leave your party, really?
Well, first of all, Dennis, and good afternoon, Khemraj, and all our viewers. I'd like to remind that the parliamentary opposition is referred to as the People's Progressive Party Civic. So for the rest of the discussion, I'd like to be referred as the MP in that parliamentary grouping. Secondly, I am disappointed in the view that was expressed at the Court of Appeal. Mr. Ramjattan rightly said this matter will go to the CCJ for final determination. But I'd like to remind all of our viewers and all those that are part of this discussion, Article 106(6) never used the word absolute majority. I was in the Court of Appeal like you, Dennis, when the arguments were being made, I went there in my personal capacity so I can be educated on what is transpiring, because when you have constituents that you have to talk to, you don't want to be depending on hearsay. And I recall the Chancellor on several occasions, while Mr. Nandalal addressed the court, invited him to accept that Article 1066 referred to an absolute majority, and in every instance he declined. In every instance he declined. I think in one instance he also indicated that the framers of our Constitution was not short on ink. That's why the word absolute was left out. It was not a shortage of ink that caused the word absolute to be left out. And we stand by our contention that a majority of 65 is the greater number, which is 33.
Yes, but Mr. Edghill, surely, and Mr. Ramjattan, must be taking into consideration what was said then by then President of the Caribbean Court of Justice and also other judges. Some case concerning the validity of the third term here in Guyana, that there are three levels of majority, so to speak. That was a simple majority, an absolute majority, and ultimately a referendum. So in the context of the Constitution, did you factor that in your reasoning to say that there is nowhere it is mentioned? Well, of course, literally it is not, but nowhere is it implied, at least, that absolute is a relevant term in interpreting Guyana's Constitution.
In the issue that we're dealing with, it has to do with the case, the clauses that govern the no confidence motion, Articles 1066 and 1067. Any Guyanese simply reading the Constitution would understand that what is required is a majority of all the elected members. The question must be asked, were all 65 members present and voting? The answer to that is yes. The greater number voted for the motion, which was 33, 32 voted against. This matter, I'm sure, will be argued at the CCJ. They will have a final determination. At this stage, we still, I would believe, and I speak here this afternoon, not that we have been able to meet as a parliamentary group as yet to discuss all of the implications of this decision, but following it, and my own understanding, and I think representing the views that are across this country, coming from various quarters, and a number of calls that I've received from the United States and Canada over the evening of last night, people expressing their views. It's a matter that needs clarification. I think the Chief Justice in her ruling on this matter was correct. We have two judges in the appellate court who felt differently. The court must be respected, and I would want to call on all Guyanese to show respect to the court. There should be no language that is used that would disrespect our Chancellor and our appellate judge. At this particular stage, there is no evidence that we should even encourage that kind of a behavior. But you know what is important, Dennis, and I think the viewers might want to hear, on every matter of law in these cases that were heard, the government arguments were struck down. The only one that was upheld is the issue of the mathematics. Was Charan Das's vote valid? Yes. Was his vote saved, even though he was a dual citizen? Yes. Did Article 165(2) protected him? Yes. All of the issues that the Chief Justice ruled on issues of law were upheld by all of the judges in the appellate court. When it came to the mathematics of the majority, that is where the issue is, and I think that is the issue that would have to be clarified at the CCJ.
Mr. Ramjattan, does your party, and do you feel somewhat bruised by the fact that there were other elements in the matter which were struck down by the Court of Appeal, and in fact led to an upholding of the High Court's decision?
Yeah, you can say that. I was very much disappointed in the fact that the Charan Das's vote was saved. And I am hoping that the Attorney General and Mr. Neil Boston and Roysdale Ford lawyers for the various parties that argue that point, that they are going to counter-appeal the decision of the Court of Appeal on that regard. As a matter of fact, I believe that if I was the lawyer for the case, on all those matters that we lost, there should be a counter-appeal on those matters so that the finality of them can be heard and addressed on by the Caribbean Court of Justice. So not because we won only on the point of the mathematics, we must go on to argue the case as to whether that constitution saved his vote, the provision that says notwithstanding his participation inside of the parliament that validated the proceeding, what is the meaning of that? I am seriously of the opinion that it still could not save his vote. What it did was to save the proceeding so that the proceeding is not invalidated. So it is important that our lawyers do that. So it is not as if all these matters have been brought to a head yet. All these issues should be brought to a head by the Court of Appeal, by the CCJ, upon a counter appeal, as we lawyers call it. So the appeal will be made because, of course, I could understand the disappointment of the opposition on the matter. But our lawyers, too, should ensure that they counter appeal on all these grounds so that live will be these issues at the CCJ so that they could also bring all those to finality and so that we can then know for certain how we move on in relation to votes of dual citizens and all of that.
Yeah, gentlemen, this takes me to another point, and that is the whole question of dual citizens. What happens now? I know, for instance, Ms. Gail Teixeira of the People's Progressive Party Civic has made it very clear that she is prepared to give up her dual citizenship, to renounce it. That's her Canadian citizenship. What happens now? What would you like to see as a demonstration of political goodwill and commitment to the Constitution of Guyana? Should the current dual citizens resign, even as we await the ultimate decision by the Caribbean Court of Justice?
Who go first?
Mr. Ramjattan?
Yeah. I think that the logic of it, I know that the law sometimes is not all logic, it is experience. The great Supreme Court Justice, I think, out of America had indicated as much. The law is not logic, it is experience. And we have to, in my view, logic here will mean that indeed they might have to resign. I don't know what will happen, but if I had my way, that would be the natural course of events, or unless they renounce their citizenship from those countries overseas.
But surely renunciation of citizenship takes a while, so we can look at the possibility of that taking at least 3, 4, possibly 6 months. So where does that leave the MPs who have dual citizens? Should they wait until the renunciation process is over, or should they do it now as a sign of goodwill that, look, I'm giving up and I'm awaiting the renunciation?
You remember here what we had was the Court of Appeal saving their votes.
Yes.
So you have the argument that, look, although they're dual citizen, their votes were saved, and so it can be counted.
Right, I understand that, but I'm talking a demonstration of political goodwill to say, okay, well, notwithstanding the fact that they're saved, we here still believe in the strict provision of the Guyana Constitution. That
is where my logic is taking me, Dennis. And I believe, indeed, that is the difficulty and challenge we'll have. There is a resignation mode that will have to be probably put into operation.
Thank you, Dennis. This matter is a matter that must be addressed, not just from the standpoint of the rulings of the court, but it's also a moral argument. If the government challenged Mr. Charandas's citizenship, being a Canadian, or caused to be challenged, either they challenged or caused to be challenged, and that became the subject of a dispute, I think the government should lead the way. Every dual citizen who sits in Parliament must now resign. The government should lead the way. Instructively, last night, the Vice President, Mr. Carl Greenwich, my good friend, who made the announcement and made an address to the nation about these matters, should have at least indicated he was affected by the ruling of the appellate court, because it upheld that as a dual citizen, he ought not to have been in the Parliament, much less our foreign minister, representing us around the world and acting as president at this particular time. So the moral argument is there. You took the initiative to question Mr. Charandas's citizenship after you would have placed him in the National Assembly as your representative, when you were caught in a bind with Mr. Charandas's vote that caused your government to be toppled. One of the grounds in which you challenged that action was his dual citizenship. The court, the Constitutional Court of the Chief Justice ruled you can be dual citizenship and sit in the National Assembly. All three judges upheld that decision in the Court of Appeal. The government must lead the way, because their moral authority on this matter is being inspected and questioned. The People's Progressive Party Civic, I think the General Secretary has already addressed this issue and he even named the dual citizenship on the PPPC's side. He has addressed this matter at one of his press conferences.
If the government does not lead the way, then what happens? Would you then be perhaps paving the way there in some manner to allow your dual citizens to go back to Parliament when the sitting resumes? The next sitting, sorry.
I cannot say that definitively.
Or are you trying to walk? Or are you trying to? But I can tell you,
the public position.
Back what was already said by the PP Civic, that the dual citizens will not be returned to the House.
Well, I can only tell you what is the current position is what the General Secretary would have indicated. And last week, Saturday, you were at a forum where Madam Teixeira addressed this matter as well, about her own personal dual citizenship. So I cannot speak for Madam Teixeira any other thing than what she said, and I can't.
But you're saying that the government should lead the way. Are you now leading?
The government should lead the way.
So if they don't, what happens?
Well, I don't think that the PPPC will ever take a pattern from the government on what they do, because this government has taught us what not to do. That's one of the things that this government has taught the PPPC, what not to do, not to betray the trust of the people of Guyana by saying things and acting differently. So I think the PPPC will stand by its word, and we have a moral obligation to stand by what we say in public.
I rather suspect, Dennis, that the PPP Civic is going to take the lead from the government on the matter. You watch it. I have given my personal opinion on the matter just now, and so it is important. Of course, it's a collective effort, what we're going to do, because we have, let's say, I don't know how long the Caribbean Court of Justice will take to deal with the appeal, but of course, between this time and that time, obviously Parliament will be in session and convene. So it is going to be interesting still. This country is full of interesting developments.
Well, Dennis, if I could just make an intervention, I am very concerned about the statement my colleague, Mr. Ramjattan, said. Would the government proceed to convene Parliament on a ruling of the Court of Appeal when the government itself in the beginning says this matter will be determined finally at the CCJ? Here again, the moral argument has to be made. You in your beginning said this matter will be determined at the CCJ, no matter how it goes. And because you have a 2-1 ruling at the Court of Appeal, is the Vice President telling the nation that before the CCJ determines this matter finally, we will be going back to Parliament?
Oh, absolutely. We have no confidence has been invalidated by that 2-1 majority of that hierarchy that we call our court system.
But not the finality.
But when the Chief Justice ruled that you should have resigned and Cabinet should not meet and that you should have elections within 90 days, you did not comply with the Chief Justice's ruling, you appealed it. You appealed it. You applied for a stay, and the stay was not granted, but you did not act on the Chief Justice's ruling. Why do you want to reconvene Parliament with a majority decision at the Court of Appeal when this matter has not been finally determined by the CCJ?
Because we have gotten a court that has said that we are a legal government.
So you only act when you get a court that says what you pleases.
Yeah, but Mr. Ramjattan,
it's not that.
Excuse me, Mr. Edghill. Mr. Ramjattan, how then do you tell the Guyanese public at large across all classes and strata that here it is that on the one hand you challenge the High Court's decision that says that the vote was validly passed. Now, when the Court of Appeal says that the vote was invalidly passed, you're saying it's now time to go back to the House, etc.
Because we have that as the authority, we try to be not as to defy the court, High Court, and we try to respect it during the couple weeks or the month or so that we had to await the decision of the Court of Appeal. But now that the Court of Appeal has set it to start to 4, it goes right back to the 21st of December. And what that means is that that was not a valid no confidence motion, and so that we can now go back to Parliament.
Well, how do we know that that is right when you're awaiting a decision finally?
Because at the moment now, we know by virtue of the 2-1 majority, it is right, and we're going to use our authority there until such time as the CCJ say that it is wrong. That is what you do.
So when the CCJ rules, if the CCJ rules that the no confidence motion was validly passed, your acts that are taking place between then and now, how would that be considered? Don't let us complicate this matter. I think Mr. Ramjattan is a lawyer.
Let us hear Mr. Ramjattan.
I have done that before. I was a lawyer in Esther Pereira, in which a government was invalidated as a result of an invalidated what you call voter ID card and all of that. And the court gave a consequential order. I am absolutely certain that the CCJ, at the appropriate time, if they rule that the no confidence was in order, is going to make a consequential order in view of what has transpired. And so it will very well say at that point, it being a valid vote, might very well, assuming they win, that is the opposition win, Mr. Nandalal wins in that score, it might very well then go on to say, well, elections has to happen within a certain period of time and called by the president and all of that. And also all acts that happened during the course up to that point in time is validated under the doctrine of necessity. The doctrine of necessity is what takes care. You do not want to subvert the Constitution by an interpretation that is going to make mockery or a vacuum in governance. And that is something apparently the opposition members and a lot of members of who I call the Chatterati, talking plenty, don't seem to understand. It was applied here in Guyana in Esther Pereira. And quite frankly, I must say, not blowing my trumpet, that I had introduced it to the court for Justice Claudette Singh at the time.
Mr. Ramjattan, I wanted to ask the question this way. Does yesterday's decision have the effect, you would say, in a way, of a stay of the decision by the High Court and the conservatory order? Would you say in some ways...
It is far superior to stay and conservatory order. It is a substantive order that gives back the power to the government to bring back the normalcy prior to that 21st when the vote was taken, and that is it. It is far superior to a stay and conservatory order. It enhances the power of the government back to the 20th of December 2018.
Well, just in case you're just joining us, you're listening to a live talk show, town hall meeting originating here from Georgetown, Guyana. Our panelists this week are Minister of Public Security, Mr. Khemraj Ramjattan, who is also chairman of the Alliance for Change, and Mr. Juan Edghill, a parliamentarian for the People's Progressive Party Civic. We're discussing the topic, clarity of the Court of Appeals decision and moving forward. Looking at what transpired before all of this, we had a lot of back and forth, a lot of political bantering and bickering, so to speak. What you gentlemen see are the negatives and positives, the good and the bad, so to speak, that were yielded from the stalemate in a no-confidence motion? First of all, Mr. Ramjattan.
Dennis, it's a lot of learning. It is going to be the settling of a number of constitutional interpretations. It is also going to be useful for knowing those, so for certainty in future. It is also going to help us understand a lot more about our politics too, as to what transpires in moments of constitutional, you can call it crisis, you can call it controversies, whatever the term, at this point in time. Uncharted waters, charted waters, whatever. The trouble is that it is good that our democracy is passing through the phases and understanding more and more on these matters. It will hold us in good stead for the future. We will know the arguments that will be made by persons who, when in government and then in opposition, would have taken and all of that. And the country itself, especially as more and more young people get to be educated on these issues, they will come to appreciate what democracy is. Because people sometimes find it that, you know, it is red line crossed on the sand. It is not necessarily that. We have to appreciate we are dealing with human beings, and red lines are not the best thing. We have to learn to appreciate the other, tolerate the views of all, and allow the final institutions, or the institutions that bring finality to a number of controversies, be allowed to operate.
Mr. Edghill?
Yes, Dennis. And I thank Mr. Ramjattan for his comments that he just made. But what is on open display for all of Guyana is the bad faith approach of the coalition government. And let me explain what we're talking about. In 2014, Mr. Ramjattan's party joined with the APNU to bring a no-confidence motion against the then government of which I sat as part. They had 33 votes, we had 32 votes. They intended to win that vote with 33 votes. They intended to win that no-confidence motion with 33 votes. The parliament was prorogued, we had elections. They came into government with 33 seats. We moved a no-confidence motion against the government of 33. They intended to use Mr. Charandas's vote to get 33 to defeat the opposition's motion. Mr. Charandas voted with the opposition. The motion was carried in the National Assembly. What did the government do? Having accepted defeat the night, the next day, when they met in their war room, they launched a legal offensive to see how they could overturn it. Bad faith. Mr. Ramjattan has spoken about the Esther Pereira case. He was a lawyer in that matter. It was the two parties that agreed to use voter ID cards in the 1997 election. When the PNC lost that election, they went to the court and had the court vitiate that election. Bad faith again, an agreement that was not upheld with a legal challenge. Now, what am I saying to us? This era that we are in, we have to start dealing with this issue of trust. The issue of trust is what is at stake here. Could we trust our political leaders to behave responsibly? Could we get statesman-like approaches, or are we in a game of chess to see who could outmaneuver who and who could get an upper hand over who? Are we prepared to operate on the standpoint of principle? Are we prepared to provide leadership from the front where people could trust us and people could understand that these are men and women of honor? The opportunities that are provided right now, Dennis, and the way forward is not just the decision of the Caribbean Court of Justice. It's the maturity to enter into serious political dialogue to solve some of the issues that we have before us.
What is stopping this dialogue? What stops real dialogue between and among political parties in Guyana in recent times. I'm asking this question against the backdrop of the fact that prior to the death of Mr. Forbes Burnham in August of 1985, I'm told, and perhaps you can correct me if I'm wrong, Mr. Ramjattan, because you were still then a member of the PPP, that the major political leaders at the time, Mr. Burnham and Mr. Jagan, actually had backdoor discussions, secret discussions about finding a political solution out of our division, so to speak. Why it is not working these days? Why is there such a discussion?
Well, it's the personality types. I think Jagan and Burnham were peas from the same pod, literally. They understood this country's history. They understood its ethnic politics. They understood politics generally. And they were friends, although you can say that they were arch enemies on the public front. But they were talking all the time. When Burnham started getting socialistic, he called in Chetty Jagan, and he was far more socialistic than him. Nationalization, they agreed to, a whole lot of other things, and so on. So they always had that relationship. And leaders of opposition and presidents must always engage. And that is why President Granger has been asking all the time for engagements. But some people would sometimes use, and I come back to the argument made by Bishop Juan Edghill here, that sometimes when you feel that you have the institutions that bring finality to certain decisions, you want to use that. And that is why I rather suspect that there was this problem of tremendous distrust because the High Court ruled in a certain way, and the opposition felt that they are going to win at the Court of Appeal and win at the CCJ too. They didn't allow that. And that is the kind of thing when you now almost getting there to the 90th day, people feel that you're going to be illegal. You must chase out Ramjattan and Magamutu and Granger from Borbis and all kind of thing. It didn't go that, it wasn't needed to go that far. But I want to say that once you have institutions that bring finality to matters, you are obliged to use them, because no matter what, even if you go, because a political pact, as it were, between opposition and so on, is something different from a commercial transaction between two parties. There will be, because it's a number of things at hand. Power is one, and that is a big, big thing. You have to understand that. Some people want back the power that they lost after 23 years and a whole host of things. But understand this. Take, for example, the moral question being argued. When we had this thing about 2 terms, president, we have a fellow there bringing through a litigation that say that you could run a 3rd term. Where was the morality? Why didn't Mr. Jagdeo or so go and indicate that I will not become a president again, even if the court so ruled that it is going to be a 3rd term thereafter? No, well, this is the morality, because he knew that he will have to go to the court and let the court rule. I am certain that if the court would have ruled the CCJ that he could run a 3rd term, he was going to go back there, although he was the one that signed the constitutional amendment for only 2 terms and no more. So understand it. That's how the democracy runs. That's how the human behavior. Understand it. Human beings are not angels. Bishop Edghill would know that. And whatever is the legalities that they could be used and be utilized, it will be held on to by the politicians of the day. We held on to the court cases saying that indeed we will go to the CCJ. And there's absolutely nothing wrong with that, improper about that, or illegitimate about that. And we have basically won the 2nd round, as you say. We could very well lose the 3rd round.
Yes, but gentlemen, let us look at it from the other perspective. And this stalemate that we had over the last few months or so provide both the opposition and the governing coalition an opportunity to engage in mobilization to keep their support base intact. And did it allow the coalition to intensify what some say was lacking? That is, it did not present itself a lot on the ground among its supporters and its non-supporters, so to speak, to ensure that they were always in contact with them, dealing with their concerns and so on. Did this stalemate provide that kind of mobilization opportunity?
Well, Dennis, if I go first on this one, let us start with the tabling of the no confidence motion.
No, we know that that is a given. We know that that is a given.
The mobilization you're talking about and the opportunities. Right. 3 days after local government elections, we tabled the no confidence motion because 63% of the popular vote went to the People's Progressive Party Civic of all that were tabulated. We saw an opportunity there to hold the government accountable and say, look, your people are not going with you. We tabled a no confidence motion. In our minds, we won it. Our people were mobilized across the country, and I want to say they remain mobilized. The fact of the matter is, since then to now, we have seen the activity of the government. Their fanouts in Georgetown. Mr. Ramjattan was on Juan and Wednesday. I'm sure he was disappointed with the attendance.
I was very proud of the attendance, quite
frankly. You mean you're proud of 15 people attending?
15,
come
on.
To hear the vice president?
Get your maths right.
We have intelligence across the city, you know. Ramjattan knows that too. But the point of the matter is, this government had become aloof. When we filed the no confidence motion, it wasn't just about winning. I don't know that we knew that we could win. We wanted to convince others to vote with us so that we could win it. But it was one way of saying to the government, you cannot continue to treat your people the way you are treating them. So we got that. That was one. The government woke up. They had to come out of their bubble. They had to start being aloof, stop being aloof, and they had to get down to the ground. So their makeup started to get sweaty because they had to now get into the markets and start talking to the people. And of course, they have not yet fully endeared themselves to the people. The second thing that is of importance.
Before you go to the second point, Mr. Edghill, can I allow our online questions to be posed to you? I think we have a few online questions. Okay. So we'll go now to our co-moderator with the questions, and he'll have them posed to you.
Hi everyone, my name is Kimberly Satar, and I'll be reading a question from Betaram Ramharak, who asks, would the coalition and opposition replace their members with dual citizenship?
As I have answered already, I feel that the logic of it is that, yes, we will have to do that. We have to now reach as a cabinet rather than a ministerial plenary to ensure what the final decision will be. And of course, our president is coming back this afternoon. So we will certainly make major decisions in relation to that. The court cases have indicated that obviously that is what we will have to do. But it is to be seen as to what will be done. That is a moment that we'll have to wait for.
From the PPPC standpoint, we can assure the caller and all other Guyanese, we will respect and honor the Constitution and the ruling of the courts.
Any further questions from our online viewers?
Thank you. I have one more from Brian Singh, who asks, can Mr. Ramjattan answer as to how the court ended up to an absolute majority when the Constitution says majority?
Because of the distinction and the different formulations that the Constitution provided for in relation to these matters. And also because of the judicial reasoning in the Richardson case, as mentioned by Dennis just now. If the Constitution wanted 33, Article 106(6) would have said, instead of a vote of all the elected members, it could have said a vote of those present and voting. It could have said that. Just like the 33 required for passing of any bills, or those who are present there above a quorum could pass it. But because of the formulation and also because of certain other articles in the Constitution saying 2/3 majority vote of the elected members and all of that, and an interpretation given by Sir Dennis Byron, the president of the past CCJ, a past president of the CCJ, indicating in the Cedric Richardson case, we utilize that jurisprudence to make the argument that although the word absolute was never used in the Constitution, it obviously meant an absolute. And in that case, of course, as reminded just now, there's a simple majority, there's an absolute majority, and there's the referendum.
That is, Mr. Ramjattan did not tell the caller that the Constitution also refers to a 2/3 majority of all elected members on specific matters. And that 2/3 majority is not 2/3 of those who are present, 2/3 of all elected members.
Yeah.
In the same way of 106.6, a majority of all elected members. So the Constitution is not clouded in what it wants. This will continue to be argued elsewhere at the CCJ, like has been indicated. But just to also indicate that it is clear that this matter was accepted by the government. The night of this 33-32 vote, the Attorney General sat there and did not rise in his seat to object that 34 was needed. The Prime Minister went to a press conference and accepted the government's defeat. The President the next day, through a statement from the Ministry of the President, accepted the defeat of the government and he will comply with the Constitution. So the judicial arguments that are being made now, it is a convenient argument. It is an argument of convenience, and that is a real moral question that I think the caller has in mind and how it could be addressed.
I could address that, Dennis. Please allow me 1 minute.
Yes,
Indeed,
because I really wanted to know whether those have any legal weight in the courtroom.
Of course it does. And that is what I'm saying, that when I had done the research in relation to the New Confidence of 2014, I was the one that did most of the research in relation to that. I honestly felt that it was 33. And I've made a public pronouncement to that. But when I got from Stephen Fraser his legal opinion, which he had given to Anil Nandalal, and which ought to have been used by Nandalal then, because had it been used by Anil Nandalal, we would have known today what it is, because he would have carried it to court. And for all you know, if they knew that it is 33 or whatever it is, or it is 34, assuming he had used it and it had gone right up to the Court of Appeal, and the Court of Appeal had ruled that it is 34, then we could not have passed. You might still have had Donald Ramatar, the president, for a full 5 years. But we have to understand that these things must be taken to a finality. Now, when I got the decision from the brilliant Stephen Fraser,
the opinion, not the decision.
Please. And I got it, and I then realized that this changed my perspective on the point. And every good lawyer, notwithstanding the novelty of an argument, that does not do any embarrassment to its validity. And indeed, we wanted to get where we are today, we had to utilize an argument like that. You can talk that we are immoral or whatever. The trouble is. The trouble is that we made a very good signature into that, to that argument, and we utilized it. And it will bring finality to the thing now as to what it is under our Constitution, 106.6, whether it's absolute or simple to carry it to 33 or to 34. And thereafter, because elections are going to be clean, almost very, very, narrowly won in Guyana. Let us then bring this thing to a finality.
And but what I wanted to ask Mr. Ramjattan is whether the failure of the Attorney General to rise to his feet and object at that point in time could have any legal bearing, or ought to have had any legal bearing in arguments in the courtroom.
Well, I don't know. I don't think so. If he had known and he didn't rise up, there should be some criticism of that. But I honestly felt that 33 was the number, and that is why I didn't get up and say, only when I got the 34 from Stephen Fraser and also from Nigel Hughes.
Do we have any more questions?
I want to ask Dennis for clarity for Mr. Ramjattan. Would he explain to all of the persons that are viewing, had the Donald Ramotar government been defeated by a 33 opposition, and we had said, based upon Stephen Fraser's opinion, that 34 was required, what would have happened in Guyana? Let Mr. Ramjattan tell the world that.
Exactly what is happening here.
Taken Mr. Stephen Fraser's opinion, which the Attorney General at the time had received, and we had said, let's go for the vote. 33 can't win it. We need 34. Tell us what would have happened in Guyana.
Exactly. You would have gone to the court, wouldn't you? But it is
would have been allowed to go to the court, Mr. Ramjattan?
No. What is very immoral then was that they didn't want us to debate the thing. They went and prorogued Parliament. Which is constitutional. Exactly.
You see, that's the point, Mr. Edghill. The Constitution is there to be exploited, I suppose, by all of the lawyers and the politicians as best as they can.
Exactly. So there was an institution that they could use, and they used it. So this morality and distrust that arises from the immorality of the they did that. They then went and prorogued Parliament, which means the termination of Parliament. So when Parliament would have then become reconvened, that no confidence motion would have died. We would have had to go and do it all over again. That is what is the meaning of prorogation. So they extended the life from almost, if we had won on the 33, we would have had to have the elections as they're asking for 90 days. But they then extended it to 8 months. We had the elections 8 months after we filed our no confidence motion.
But Mr. Ramjattan, aren't you and your government happy that this no confidence motion was tabled? Didn't it give us an opportunity to go out there and actually be among the masses again in large numbers? Something that even some of your supporters, meaning the coalition supporters, have complained about, that they felt that they were being far removed from the people who they elected.
Absolutely. Look, I am very happy. It has enjoined all of us to get out there to do the work at the grassroots level, and we are doing that. It has sometimes, in these developments, what you call unintended positive benefits. This has had an unintended positive benefit. I take that.
So what stopped you from doing it in the past, prior to the no confidence motion?
Because we felt that the elections are going to be in May next year. Honestly, we felt that it was going to be May next year or with the full 5-year term, and then we will obviously go and do a campaign and all of that. When you are now in this kind of a new development, you had to go now and ensure that you activate back your campaign at a quicker pace, and of course earlier, and that is what happened here.
But Mr. Ramjattan, can I just press the point? You were a long-standing member of the People's Progressive Party. Is this the way it is done, that you wait until it's nearing the election cycle to go out there and be among the grassroots? Or is it a continuous process?
It is not. It is always a continuous process, but the high activism is quite visible. It happens, come on, this is how a democracy works. You don't have campaign kind of outreaches all the time in American politics.
I'm not for one
exactly.
That.
Yeah, but you ease up because you have your ministerial functions to perform. And that's a lot of functions you have to perform. A number of us were not doing it as actively as we ought to because we were prepared for a 2020 elections. And that is how it is normal. You don't just go, the opposition got plenty time, at least the leading members, because they are in opposition, they're not have a ministerial portfolio, and they will go almost every day. But we have lots of work to do. You have to make overseas trips, you have to go to conferences, and that is the honest truth about it, Dennis, as I can give you.
Dennis, if I could make an intervention here.
Quickly here, Mr. Edghill.
I would like to sincerely thank Mr. Ramjattan for admitting to the people of Guyana that his government was aloof, insensitive, out of
Did I
touch.
use those words, Dennis?
Out of touch with the reality.
I'm not so sure you went to that length.
Aloof, I never said.
Your budgets that you pass, it is clear that it did not represent the will and the desire of the people. It was, you took away welfare from people. So you're making the point. We would have done this for 4 years. And when the 5th year comes, we'll put some goodies in the bag and we do a big, massive reach out and we buy everybody back but for 4 years, you suffer your people. You looked after yourself. You raise your salaries. You travel around the world. You live in a bubble. You don't interact with your people. The no confidence motion was a reflection of the views of the people on the ground. They were fed up with the way the government was running the country. And I'm happy that Mr. Ramjattan is admitting that this afternoon. Thank you, sir.
I am not admitting that, but you know, the bishop has his way. It's all right, Bishop. You can say what you want. The trouble is that is not an admission that we were aloof and all of that.
Let's look at this whole scenario here, gentlemen, from another perspective. How do you repair what appears to be in certain quarters some even entrenched and renewed racial tension surrounding all of that has happened here? I'm asking that in the context of the fact that Mr. Charles Prasad, being Indo-Guyanese, who voted in favor of the no confidence motion, may have contributed to the remobilization, at least psychologically, among the larger block of voters who are part of the coalition, mainly Afro-Guyanese, who seem to think that, okay, we will try to lock horns together because here it is again, an Indo-Guyanese man is trying to unseat the coalition to take us out of power. On the other hand, we've had a situation where it may be viewed as though Mr. Charles Prasad's vote helped to remobilize and perhaps even to bring back a lot of people back home to the PAP. And therefore, you've got on a national scale the possibility of these two large race-based voting blocks lock horns together. How do you deal with that scenario post low confidence motion, post Guyana Court of Appeal, post CCJ?
That is always going to be a difficult question because politics in Guyana for a very long time has been tribal. It has been polarized heavily. And it will come with education. It will come with a longer life in democracy and democratic practices. And I feel that all of this is but going to be the experiences for a future to bank on and to see lessons from, to ensure that we do not be tribal in years to come. We will see from post Charandas no confidence motion times the argument being made, but of course what it is that the government has done, the positives and the negatives, and by that judge them. What it is that the opposition did in its 23 years, by that judge them, rather than elucidate that it's an Indian fella that bring down a government that is known to be an Afro-Guyanese government and utilize that. That is illogical in my view. However, it still bites. It is still something that is exploited out there to get racial voting going. And so we have to cut that. Leadership also, not only the education, but leadership at that higher level is also going to help in that regard. But yes, tribal politics and polarized, ethnic-sized politics is not something that you're going to easily do away with. It has now gone to countries that you least expected. It is in France. It is in America, with the Americans being so divided by those who they say live in the Midwest and all of that, and they call them the rednecks and the ones that are more multicultural and cosmopolitan in California and New York and so on. It is a big division. In England probably, and also in a number of the European countries. So Brexit is one expression of it, or manifestation of it. So it is going to be a very difficult thing. The university professors and sociologists and anthropologists and so on will have to give us some of the answers. But it is always going to be a difficult challenge for a multicultural country to say, what then? How do we move forward?
Mr. Edghill?
Yes. Thank you, Dennis. The People's Progressive Party Civic was public by saying through its General Secretary that we believe that we are underrepresented by Afro-Guyanese in the PPPC, and there was a wide, massive outreach to that community. The 2018 local government elections provided us with an opportunity to measure. In Georgetown, we moved from 2 seats to 7 seats. In Linden, we won a seat. In Kokwani, we won 2 seats. In Bartica, we moved upward. I think we went to 5 seats. In New Amsterdam, we improved areas that were traditionally PNC strongholds, as Mr. Ramjattan would know. So the party's acknowledgement of its underrepresentation among Afro-Guyanese led to a massive outreach to Afro-Guyanese communities. The 2018 local government election provided us with opportunity to see how this measure. We have more Afro-Guyanese that have come in. As a matter of fact, nominations, David, I think you witnessed at the 2018 local government elections nomination day at the Critchlow Labour College. I had other duties to do in Linden, and when I arrived at Critchlow Labour College, a very senior police officer commented that the PNC types, APNU leadership, was literally counting in the PPPC's procession how many Afro-Guyanese were part and who were candidates. So there was even an acknowledgement from the PNC on that day that look what is happening here. The PPPC is making inroads into Georgetown. Miss Valda Lawrence, who is now the chairman of the PNC, went to Sophia, where we won, and says we have a strategy of how we're going to get it back. They can't last. And it was an admission that they had taken for granted that they had the transport and lease and ownership for Afro-Guyanese, and they had neglected them. And the PPPC had gone out there and embraced the people, and we had gotten support.
Yes, but Mr. Edghill, the critical basis for my question is the fact that we had Mr. Chardas Bassad voting in favor of the no confidence motion. How do you deal with the possibility of perceptions of race playing a big factor here and can result in that kind of widening of the gap between the two races politically? That's the basis of my question.
Okay. It is a matter of great concern. As a matter of fact, I did see the comments on Facebook. Known personalities who I expect better from was using the language of race. But Mr. Chardas came from Kanji, where he saw the suffering of the sugar workers, the families who weren't able to send their children to school, and he acted. The bottom line is we will always continue to have those perceptions, and we have to move from the standpoint where Indians in the PNC is not cosmetic, or in the APNU coalition is not cosmetic, and Afro-Guyanese in the PPPC is not cosmetic, but they are part of the real politic, the real decision-making, and is an entrenched national-based approach. And I believe my colleague, Mr. Ramjattan, among the many things that we may differ on, understands the dynamic of getting that national approach to politics as against the ethnic approach and ethnic appeal.
Okay,
This Alliance for Change was birthed out of that understanding.
Okay, gentlemen. Before you continue, Mr. Ramjattan, we'll now go to our in-house contributor to have her questions posed to you.
Thank you very much for this opportunity. Gentlemen, thank you for educating us, and you have definitely brought much clarity to my mind on the topic of clarifying the decision of the court. My question is very simple. I am wondering if the PPP saw this as such an important step, why they did not go fully equipped to know what was the majority vote that they needed. And I'm wondering, in retrospect, if they would not think they really made a very big boo-boo and mistake. Thank you.
Well, I guess that question would be for me to answer first. Like Mr. Ramjattan, who said that he believed 33 was the majority, at all material times, the PPPC believed that Article 1066 required a majority of 33 votes. At all material times, 1066 required a majority of 33 votes. The passage of every budget, the passage of every bill in the House, everything that was done, we understood the majority of the National Assembly as 33. There was no defining in Article 106 about absolute majority. It is not written there. It's a majority of all elected members. So we never anticipated that we will have an argument of this 34 because it's a matter that we all understood. Since independence in our parliament, every vote that was won was what was required for the threshold was 33. When the APNU plus AFC put their no confidence motion, they were relying on their 33 as well. So we were satisfied that 33 was needed. We would have liked to have 36, and we were expecting 36 on the night, but I'm sure the behavior of someone, Mr. Charandas, didn't allow the others who would have voted with us to vote, because conscience was really working that night. People understood the reality of Guyana.
Hey, Bishop, I disagree. None of conscience. None of conscience.
Well, until we could have anything different, we gotta accept conscience.
Please understand this. Look, I want to say that that explanation given by Bishop would be somewhat disingenuous, because there was, from a top lawyer who was sought after by the Attorney General, an opinion where, with all the legal jurisprudence and so on, coming to the state that it is 34. That is what good lawyering does. If you now felt that it is 33, and then somebody like an Einstein come and say with the theory of relativity that this is not how it operates, this is not Galilean times, it is this way, this is 34 now, why didn't you utilize the opportunity? And let me say this, it would have again brought finality since 2014 on the matter. But you missed.
I did ask the question earlier.
That is
I did ask the question earlier. What would have Guyana been like had the APNU AFC voted 33 in 2014 for a no confidence motion, and the PPPC with 32 says, no, you don't have the majority?
Do we have any more questions?
If the shoes was on the other foot, Guyana would have been
any more in-house questions?
Yes, we have more questions. We have a lot of questions, actually.
Yes.
Let's go to someone in-house.
Sanchez, Your Honorable Mr. Ramjattan, on behalf of the Guyanese Overseas United, now that the grassroots communities, which are the people of Guyana, are back on the table or visible, can we rely on the government to address the social protection of the people, in specific the domestic abuse of women and youths, not on a race ticket, but on an economical ticket, as to being financially secure to receive certain services, and those who are not are being left out, which is the grassroots people, actually the people that make up Guyana, that now can we expect you to put some kind of protection in place to protect them so that they can have a better quality of life?
Those who are abused domestically in Guyana, my dear, they are protected as best as possible from the system we have and as our resources could provide. There is always the case for more resources, social workers, psychological treatment, and of course, ensuring that those who are doing the abusing will be prosecuted successfully and or be given orders from the magistrate to not be seen within 100 yards from each other and things of that nature. As best as possible, we are trying to copy the system that you have in America there. and we have gotten the domestic violence law that was implemented years ago. We are trying as best to implement it. Guyana, of course, as you know, is on the cusp of being a wealthy country, but presently it is not. And indeed, we sometimes do not have all the facilities that can take the abused women away and put them into certain halfway houses or facilities that could provide them with all the facilities of house, clothing and meals and all of that. It is a difficult situation, but we are trying our best through social protection. And I am absolutely certain as more revenue comes in from oil, that is one of the big ones that will come in, we will be in a better placed position. And you can take it from me that indeed social protection and the Ministry of Public Security is doing all that it can presently in relation to that. Now, there are going to be some cases. A very bad one was where the policeman recently went to back to the house of the abuser with the wife, and it really was very bad and insensitive on the part of that policeman, who has now been departmentally charged and was sent home for a couple of days. But again, you have a scenario there where sometimes you want to know what can be the punishment for a policeman that was so insensitive. I don't know, because that policewoman, I understand, have children too. You do not want to dismiss, because then she might not have a job to feed her couple of children that she has. It's always a difficult challenge.
And Dennis
Okay, we
we
have a lot of in-house questions that we would like to ask.
He and his government will always have the support of the PDC when it comes to the protection of our women and the protection of our young people, both in terms of their economic advancement and their personal safety and security.
Okay, so back now to New York for more questions in-house.
Minister and Bishop Edghill, I would just like to ask you guys that we have a lot of in-house questions and comments that would need to come through, so please limit your answers to about a minute so we can be able to ask a lot of more questions. We would like to now go to someone in-house who has a question.
David. Member of Guyanese Overseas United. To ask the question, I'd like to give a little context. I was born in one family, but I grew up in another family, and never did my mother tell me that I could not do something in my first family because I grew up in the other family. Now, Guyana, every time they come up here to the diaspora and ask for our assistance when it's election time, yet they promise that we as diasporans would be able to have representation in Parliament. Every time we're talking about it, but it doesn't happen. We're hearing now with this no confidence vote that there might not even be any parliamentarians who are allowed dual citizenship. My question to both of you gentlemen is, what are you going to do to assure the diasporans, not only at the time of election that we need our help, but at every time that we will have representation in Parliament? Both of you, what are you going to do about it? Thank you.
If I can start first, and very quickly, because we are in 1 minute, it is to have constitutional amendment on this issue. It is obviously constitutional amendment. I have indicated in an interview done years ago, I think it was 2012 with Dennis Chibral, I can't recall who it was, that we need the skill set of diaspora members. And we have to have them in our parliament, Ministry of Diaspora and all of that. I am very supportive of them. But it is that this aspect of our constitution that says that if they pledge allegiance to another state, they cannot be under dual citizenship and all of that, that has now come to, in a sense, entrench the position that that you have to be only with one allegiance. And that is a kind of a troubling thing for me, knowing what my policy orientation on the diaspora is. So it will require constitutional amendment. I think we will have to amend that constitution to incorporate and adopt the position that diaspora members must be allowed to participate in our parliament and our democracy.
Will the PPC, Mr. Edghill, lend support for such a constitutional amendment?
I believe that we need to participate in a broader discussion about how this matter is to be approached. The men and women, our Guyanese in the diaspora, are a valuable part of the Guyanese community. We don't just expect their money or their financial support. I agree with Khemraj. With the coming of oil and gas, the infrastructural development that will be taking place in Guyana, we will need engineers who have worked with major companies to come back home. We will need people to come in here in private-public partnerships and invest. And if people have investments and interests here, they must be able to have representation. So this is required for a broader discussion that will ultimately have to come up in the process of constitutional reform, and let's see where it goes from there. But I believe it is a matter that has to be addressed.
Okay, more questions in the House?
Yes, 1 second.
Good afternoon, gentlemen. Minister Ramjattan, Bishop Edghill, and Mr. Charbel. I have 2 questions I want to ask. And Minister, you mentioned about the Constitution. And here's my take on that. What plans are in place for the constitutional reform? Because we've talked about this over and over again. When this was in both your elections manifesto in last elections. That's one question. And the other part to it, which I think Dennis brought up in regards to good governance. So good governance for the people should be promoted at the grassroots level. And Minister, you mentioned that across the 10 regions of Guyana. And the 5 things that should be advocated for is advocacy, policy dialogue, mobilization, sensitization, empowerment. And my question to that part on good governance is, what has the government done in these 5 areas in regards to good governance?
Well, let me say the fact that we have held 2 local government elections in which people could now govern themselves at the local authority areas and the NDC areas is a very big development. For 23 years or sometime since after the 1994 last local government elections, we haven't had any. But as we kept a promise, we are going to hold them within the constitutional time, and within the 3.5 years, 4 years that we have been in government, we have held them twice. That is a big, big plus in relation to what is called governance at the local level. On your question, Diana, I think that is Diana, we also have gotten a little stumped by all the developments that have happened in relation to the constitutional reform being right now in a committee, I think the Constitutional Reform Committee of the Parliament. We had started a process. I know the Honorable the Prime Minister had started a process in which lots of work was done by Mr. Nigel Hughes in relation to how we should move forward. And a number of things were done. We now have to get the consultation going for purposes of people going to all across the regions, understanding what are the constitutional reforms that the country needs, and so we can move it forward. A lot of developments happened, one of which was this recent no confidence motion, and a number of others during the course of the year. That's as best an explanation I can give. There have been, I think, yes, I am disappointed that it has not moved forward faster, but of course we have some time now, we can all move faster in it.
Okay, I'll leave it there, Mr. Ramjattan. Mr. Edghill, quickly, you have 1 minute or so to respond because of time constraints.
Yes, we embrace Article 13. We believe that people should be consulted through their representatives to participate in the decision-making process in Guyana. On the issue of constitutional reform, we believe it should be a bottom-up approach. It should be broad-based consultations with the people. They must be able to say what they want changed in the Constitution, and not a few elite people tinkering with the Constitution to suit their own interests. So the PPPC is committed to constitutional reform, from broad consultations throughout the whole country, through the various representatives, so that we could get to yes, so that we could all agree on what we want as our supreme law.
We're back now to our New York base for more questions from that location.
Minister and Bishop Edghill, as expected, that both political parties would battle this no confidence motion in the legal arena. And yesterday's decision has sort of brought a calm that the governance could continue. However, we have to look at the people of Guyana, that it's affected the country in many different ways, that the uncertainty over the last 3 months has caused less investment attraction to the country. My question is, as expected towards the Caribbean Court of Justice decision, until that comes about, whether if there's going to be an election, should GCOM continue its process to prepare for election, so that if there is an election, that it'll be a smooth election where there wouldn't be uncertainty and problems. Again, if GCOM continues its preparation for election, then the people of Guyana would have less uncertainty, and there would be a true smooth transaction
could we allow
into election.
The panelists to answer the question?
Minister Ramjattan.
Yeah, thank you very much. I am absolutely certain that the GCOM, as a matter of fact, both parties, I think, would want that GCOM prepare for an elections. Remember, there is a third round in the battle, and you could very well not win the third round, and there will be, obviously, a need for early elections. So GCOM must prepare. And I, as chairman of my party, will urge the GCOM chairman and all the commissioners there and the secretariat continue the work to ensure that the preparation will be completed in good time for even an early elections.
When you say prepare, Mr. Ramjattan, what are you talking about?
House registration?
Or using the Carter's suggested model of creating a separate list of immigrants?
No. I would like house-to-house registration. I have argued this on the previous program, because we are going to get the list cleansed of those that are not supposed to be there, including overseas people who have now gone overseas permanently and all of that. We are also going to get young people on the list, and we are going to get people within the residencies, as I have argued. They are going to be now on the list next to a polling station that they could go in the morning time and vote, rather than, as I said, I got a lot of friends in Port Moran. They're now living in perfect harmony. Their names will still be in Port Moran. We would like a house-to-house, because that is the best way that could be cleansed.
Okay, Mr. Edghill, quickly.
Yes, GCOM, the Constitution envisages GCOM to always be ready for elections in 90 days. There are 3 instances in which you can have an election in Guyana. A no confidence motion, election in 90 days. The president at any time during the 5-year term can call elections. In the parliament is dissolved, election in 90 days. Immediately after the expiration of the 5 years of the first date that the National Assembly meets, elections must be held within 90 days. So GCOM, by its very formulation as a creature of the Constitution, its preparedness is to deliver elections based upon the Constitution in 90 days. GCOM needs to stop making excuses and start getting their operational readiness, their capacity, and to always have a list that is legal to conduct elections. Mr. Ramjattan and his government brought a motion just October of last year to extend the life of the list from 3 months to 6 months. So GCOM should always be ready with a credible list to have elections in 90 days.
Back now to New York base for more in-house questions. I'm afraid, Dr. Amaya, we're not hearing you.
Can you? Mr. Dennis, let me give one of the answers to what Mr. Edghill failed to give to the audience about 94,
please be brief,
2014, that if the PPP had questioned the validity of 32-33, we could have a civil unrest in Guyana. My other question is, why is it therefore the legal minds of Guyana cannot interpret our constitution when we brought somebody from Grenada to give us a definition of what it meant for the 33-32. And the question here now, as I just returned back from Guyana, the unrest is still there, and I want Khemraj, which I see the AFC as a rubber stamp for the whole political process, to give us an answer as to what will be the outcome if the Caribbean court say, well, an election has to be held.
Well, Ramaya, I want to tell you that if the Caribbean court rules that an elections will have to be held, an elections will be held. And please, that is what we are going to do. Don't feel that we're going to violate the court's order. We have lived in accordance with the rules of the court all the time. The Alliance for Change, as you know, you are part of it, will live in accordance with the rules of the court. And I, as chairman of the Alliance for Change and a senior member of this government, will fight down that there be a ruling adherence to the ruling. We are not there as rubber stamps, and you can say what you want. The trouble is that I am no rubber stamp. You know me, even in the PPP. That is why I was expelled, because you are known rubber stamp whenever you stood your ground at the horseshoe room of the PPP Freedom House. And when Ramjattan joined up with Mr. Granger, His Excellency now, it was not because it's rubber stamp. A lot of people will want to say all of these things, but no. It is because if the court rules, expect an elections. If the court does rules in our favor, we'll expect the elections next year. And what was the next question that he asked? Oh, he made a comment. He made a comment that we would have had civil crisis and all of that. Yeah. Well, you know, I want to tell Ramaya this, just shortly, just one sentence.
You have 30 seconds.
We did not have any crisis when they prorogued the parliament. Did we have the running down on the streets? They took away our chance to bring and debate a no confidence motion by proroguing and then extending their life by 8 months. And we didn't burn down Georgetown as Ramaya is trying to insinuate there.
Okay, we're getting closer to program time, so it's important that you be very brief.
Yes, GCOM cannot be the handmaiden of the administration by offering excuses. We need 148 days. We need to do house-to-house registration. Listen, there is nothing about house-to-house registration in our laws or in statute. That's a political agreement that was reached in times past to get the mother of all lists corrected because of rigged elections. There is a process of continuous registration which takes place now based upon the law that Mr. Ramjattan's government brought last October to ensure that the list is valid every 6 months. There is no requirement for house-to-house registration. What is required is that you have a legal list that elections can be conducted at 90 days maximum.
Thank you. Back to New York. Sir, we are not hearing you.
Hello. Well, thank you very much for this open discussion. I hope you gentlemen just realize that when the people from New York started to ask questions, then the conversation became very futuristic. Because what I was listening to before was a lot of like backward talk of what happened and what didn't happen. When the questions were posed here, a lot of the information that had to be discussed become futuristic. We talk about Constitution, and obviously the court has ruled, and we must accept the court's ruling. But most importantly, what bothers me as a person from Guyanese heritage is that apparently the Constitution has only been used in the parliamentary. How about all these people that have been abused, been beaten, been robbed? What are their constitutional rights, Minister? I'd like you to answer that. Secondly, you talked about dual citizenship, and you mentioned, you know, you were talking about the foreign countries, Europe and America. A lot of people here have dual citizenships. That's a fact. But you tend to use these terms conveniently, like what is going on around the world. We want to hear your projective vision for Guyana, and you got to stop talking about what used to happen, and we want to hear what's going to happen. This is my perspective. Thank you very much.
Dennis, could you repeat it? Because I didn't get to hear him. There was a loud background noise being played there.
Yes,
the very first question he asked was what?
I did not get to hear him well myself. Could you just repeat the question if you're hearing us?
Okay.
Very short.
Yes. I'll try to keep it very simple. First of all, I'll just go directly to the...
Could you keep the mic a little bit away from your mouth?
Okay.
Yes.
In terms of constitutional right, apparently it's only being played out in politics and in the parliament. My question was, where's the constitution governing the people of Guyana, the ones that are being taken advantage of, the murders, the rapes, the abuse? Where does the constitution play a role in that, which you have never addressed? Apparently it's just a matter of convenience when it's come time to voting. Secondly, you speak of dual citizenship, and you said you don't know what it's going to be, but you continue to make reference to North America, Europe, but people here do have dual citizenship, and they do run governments in this part of the world. So I'd just like to know your comments on those little things for now, because of time.
Look, in relation to constitutional rights, once constitutional rights are abridged or in any way violated, the courts are the place that you go and get your remedies. We at an executive branch level too can do our best to help in that circumstance. But take, for example, like when kerosene was thrown on the boys' genitalia at Lenora police station. I took the case up for that Tyon Watson, what's his name, or Tyon Thomas, and we managed to get the judgment, I think a couple $1 million, and the fella went and get his medical treatment and he was healed and all of that. That is what you do also in America. When Americans are robbed or beaten or battered or whatever, sometimes they are cast in the lot of the population of the country. Sometimes that is not a constitutional matter that you can carry the state to say that I was beaten and robbed or my brother was murdered. I don't know about that, if that is what you're saying, that you go to the state for remedies. What the state will do is to catch the robber or the murderer and prosecute successfully and ensure that they are jailed or they whatever is the penalty. That is what is the regular thing. In Guyana, that is the same thing that happens also like in America. But where the state policemen, let's say, brutalize somebody and deny them their human rights, their constitutional rights, rest assured that you're going to get your day in court and go and prove your case, and you will get damages, you're going to get declarations, you're going to get all the remedies. In relation to the other one where you're saying we are dual citizens all across the place. Well, this is what we inherited in our Constitution. This dual citizenship thing came around long probably before, I don't know, it came from the Independence Constitution and all of that. So we now have, we have to confront it, to be accommodating to our diaspora, as we just mentioned. And we have to make constitutional amendments, because we had a big set of constitutional amendments early in the PPP term. I remember being there, but we didn't see this as being that vital now. But because of the remittances, the need for so much skills, a lot of things, we have to address that issue. And that is how you do it. Do you know how many constitutional amendments you had in America before the American Constitution came to what it is today? The first American Constitution didn't have a Bill of Rights, a human rights section.
Okay, thank you, Mr. Ramjattan. We now go now to questions from our online viewers.
My first question is to Bishop from Betaram Ramharak, and he asks, do you think partisan politics played a part in the recent court decision, given the fact that the country is so polarized today?
It's a fair question, but I'd always like to be respectful of our judiciary. They should be independent, they should be impartial, and they should be fair. I would want to stay away from casting any aspersions on any of the distinguished men and women from the judiciary. I believe they should look at the facts, they should look at the cases, they should look at the law, and their determination should be based upon that. If evidence surfaced that there was any other consideration that allowed for the ruling apart from law and fairness and due process, well then you could be assured that Bishop Edghill will be one of the first voices to condemn that kind of a behavior. But for now, I would like to show respect to the courts.
And Mr. Ramjattan.
I totally concur. This is a concurrence with the bishop there on that issue. And that is why we have that third tier. Because whatever might be, so I gave an interview with Adam Harris recently, and I indicated that half of this country would hate the decision and half would love it. That's the nature of our ethnicized, polarized, tribalized politics, come what may. But that is why we will go right up there. I don't know if any Guyanese are in that CCJ, I doubt it. And so we will all then say, whosoever feel that this might have partisanship about it, they will now have to feel, no, that is a decent decision, because these are not players that got Guyanese, or biases of whatever nature, and so they will respect it. That is why I said the CCJ will bring finality to it, whether we like it or not.
And the last,
if I could just make a 30-second intervention. I agree with Mr. Ramjattan, and I'm happy that you agree with me. But he should get his Attorney General to explain his email that says the CCJ is a black people thing, because that is of concern to Guyanese at this time.
When you get into the man's email now, Bishop, what kind of privacy?
We all saw it. We all know what happened.
Come on.
All right. I'm not so sure whether that is authentic, so therefore we cannot lay any claim to whether indeed it was factual or not. But moving along, could we have the last question from our online viewer?
That question is from Mr. Vishnu Mahadio to Mr. Ramjattan, and it asks, absolute majority is where all 65 members are present and approximately 32 is absolute majority. But if members are absent, there will be simple majority. Why is it that the appellate judge has such differing opinions on what is simple majority and absolute majority?
Just like our country has different opinions on so many things, my dear. A judicial interpretation comes from a judicial reasoning, and there are judicial reasonings that can differ. And that is the reason, I suppose, that they arrived at different conclusions. We have a set of conclusions to be drawn by a certain reasoning. Bishop Edghill and Barajagde, opposition leader, would have certain, and that is how it is. There is a great American text writer called Lawrence Tribe that wrote a book called Judicial Choices. Fantastic book. How certain judges in your country at the highest level, Supreme Court, had ruled that abortion is unconstitutional, and how some said that abortion is constitutional. Segregation laws in the Jim Crow era. Some judges ruled that it was totally something that it could be done by the white man onto the black man, and some said no, it was wholly atrocious, and a number of things, educational rights and all of that. Okay, so understand that there are judicial choices to be made, and if two judges made their judicial choices, once the legal reasoning is there, we can't quarrel with it. They are the final authorities up at that level. We'll now go to the CCJ and see what it is.
And to Mr. Edghill, your response?
Well, I
very briefly,
I would just want to say that we have to keep principle in focus in dealing with these matters. Judges make good decisions and they make bad decisions. They don't make them bad people. And every judge knows that when they make a ruling, it is reviewable. And we have to be able to trust the integrity of people, and we have to stay away from casting aspersions.
Okay, thank you, gentlemen. Well, now it's just closing comments from you, our panelists, Mr. Khemraj, Minister of Public Security and Chairman of the Alliance for Change, and Mr. Juan Edghill, a parliamentarian for the Opposition People's Progressive Party. On the topic, clarity of Court of Appeal decision and moving forward. Your closing comments in 30 seconds each.
Dennis Abroad, I'm very grateful that we have had this opportunity to talk this thing through. I hope that our explanations are understood there. They may not be accepted, but let them be understood so that we know where we stand. I respect a lot of what Bishop Edghill has said here today, and for that, the engagement must proceed. This kind of engagement is necessary. And I think that's the end of my 30 seconds there. I was counting it there. But it was very useful. Thanks again, and I would love to be here again on some other one.
Mr. Edghill?
Guyana needs mature political dialogue. We have a political problem. A political solution is what is required. No legal interventions will solve a political problem. We need mature political dialogue. And I would want to urge my own colleagues in the PPPC, as well as Mr. Khemraj's colleagues in the APNU-AFC Alliance, that for the good of Guyana and the interests of the people of Guyana, that political dialogue takes center stage and we move this country forward.
Okay, well, just before we close, we now go for our poll results from our co-moderators in New York.
Yes, and right before we announce our poll results, Globespan would just like to thank Mr. Dennis Chabot for his time and effort in moderating this program. The question that we posed to our online audience during the poll was, do you agree with the Court of Appeal decision? And 48% of our online audience has said no, and 52% has said yes.
Okay, well, there you had it, the poll results on the particular question of whether or not people agreed with the decision by the Guyana Court of Appeal, essentially striking down the calculation and for the no confidence motion that was debated and at the then time passed by Guyana's National Assembly. I'd like to thank you very much, gentlemen, for being part of today's discussion, a production of Globespan 24/7. You're invited all across the world to have a look at the program again. Tell your families and friends that they can do so by accessing the program on Globespan 24/7 Facebook page. You can like the page, share the page, forward the video so that, of course, we enhance our readership and contribution to what are worthwhile debates and discussions produced and presented by Globespan 24/7. This has been your host, Dennis Chabot. Thank you all and have a good weekend.
Thank you, Dennis.
And goodbye, and thank you for having us here.
Most welcome.